Welcome to the Family Law Frontline.
Welcome back to the Family Law Frontline with Fedor Kozlov. Fedor is the founding partner and chief litigator at the law office of Fedor Kozlov, PC. With over a decade of experience in Illinois family law, he handles high-stakes cases involving custody, property division, domestic violence, and complex divorces. I'm LeAnn Lyon, and today we are talking about discovery in Illinois divorce cases and how information is gathered when disputes become contested. It's good to see you again, Fedor.
Good to see you, LeAnn.
Fedor, once a divorce becomes contested, when does the discovery phase begin, and what role does it play in Illinois cases?
Well, discovery is a major tool in civil procedure, in any civil procedure, in divorce cases as well. When it starts, you can start your discovery as soon as you file your petition for dissolution of marriage. You can, but again, when you start discovery, it's pretty much means that the divorce is contested. However, discovery is divided in several um, uh, different subjects, I should say. So first of all, when you file for divorce in Illinois, well, then at the very beginning, you have to submit what's called financial affidavit. Financial affidavit is a document where you disclose all of your income, your debts, your property, things like that. And so is your spouse has to disclose all of his or her income and things of that nature. That doesn't necessarily mean that your divorce will become contested or will remain uncontested. When it becomes contested is when you submit written discovery, interrogatories, a request to produce. You can file a request to admit, and you schedule your depositions. So that's the discovery phase of those things. And remember that the discovery can relate not only to financial issues, it also can be related to child related issues such as visitations. What are your hours, how will you work, how you plan on spending your time with the child, and things like that.
So, what tools are available in Illinois discovery, such as interrogatories, document requests, subpoenas, and depositions, and how are they used differently?
One of them, as you mentioned, is a subpoena. Subpoena is a great tool. You can submit subpoena at any time if you feel like. So there are two different things. I'll pause for a second. You can submit notice of production. So notice is always sent to the other side. You don't subpoena the other side. You send them a notice. So every time you have a party, you send them a notice and you request them to produce something, provide or answer, things like that. Subpoena is when you, as an officer of the court, as an attorney officer of the court, you reach out to a third party. So like let's say, in a financial affidavit, you discovered later that your spouse didn't disclose some kind of investment account, and you don't know what's the value of that account. Let's say he or she avoids this answers. You can always subpoena the bank, or you can always subpoena the 401k or whatever that can be. You send a subpoena. You might send them a check. It's usually not a big amount of the check. It's anywhere, I've seen it anywhere from $25 to $150, and you request that they provide certain documents within a specific period of time. Again, what makes the divorce kind of complicated is that when parties play this financial or this discovery games, let's put it this way. Discovery games controlled by Illinois Supreme Court rule, discovery process, not games. Discovery process controlled by Illinois Supreme Court rule 201K. And it provides how many questions you can ask in a interrogatory. It's up to 28. How many requests to produce you can make. So it's not an abuse of discovery. At the same time, people parties have to respond to discovery within certain amount of time, and then if they don't respond, they have to provide explanation why not. And there's this popular rule 201k, because courts don't like motions to compel and things like that. They want the lawyers to discuss all these discovery issues over the phone or by email and produce it to court without any additional motions. Very good tool that I use a lot is called request to admit. So request to admit, you talk to your client, and that the other side, let's say I represent a wife, and she's been married for about 20 years, so she knows the family affairs, she knows the husband's business and things like that. And she knows the income, and she knows that he purchased some kind of property out of state. And that's what you can do. You can put it in the request to admit that of this and this date you transfer this amount of money to this bank, admit that this and this date you purchase this property, admit that this property is only in your name, admit that this property was purchased during the marriage. And the other side, in this example, husband has to respond. And obviously you have to be honest, and say, yes, I did it, or if I'm wrong, no, I did not. And then let's say to the question that the property is in your name, let's say he transferred the property to somebody else's name. So he has to say, no, it's transferred to a different name. That eliminates a lot of misunderstanding and objections and things like that. And it's easier to do a trial later on.
Can you walk us through a case where discovery uncovered information that significantly changed the direction of the litigation?
Yes, it happens a lot, especially in with the financial issues. What happens is um, the parties, with money, try to protect their assets, and they think that if I went to work every day for the past 20 years and I earned this 401k, this is mine. Where in Illinois, everything that people earn during the marriage is considered to be marital property, subject to 50-50 division. Of course, it's a guideline state, we're a guideline state, but it's a 50-50 division. So everything that you earned during your marriage is marital property. So what happens, and then you ask about the case, the most recent case is that the husband cashed out about $200,000 of his personal, like he thought that it's personal, of his pensions, and he cashed out. He paid the fine for it, but he moved the money, and he claimed he didn't disclose it to anybody. He didn't disclose it to anybody, so the wife didn't know about it in that case, and it turned up in the discovery by way of subpoena. And it was interesting about it because he also worked in the same bank where he had this savings. So by sending a subpoena to the bank, we found out that there was this money that were moved. It's called dissipation of marital assets. And when it seemed like to be it was uncontested divorce because they didn't have any kids, and we were about to sign marital settlement agreement when we made this discovery, and that stopped the whole process and turned into a contested matter. And at the end of the day, he had to pay out the wife 50% of the 401k that he saved through his work, but it is marital property.
Absolutely. So, what happens if one party resists providing information or just flat out fails to comply with discovery requests?
Well, you ask for sanctions, so you have to be very aggressive representing your client for these purposes. The courts, the judges, they don't like these fights. They don't like the discovery fights. And remember, when you do all of these moves, when you do the discovery, you have to keep in mind that there's going to be a trial. And when you show up at trial, and everything has to be disclosed, and the trial is not going to deal with discovery issues. And that's what I heard over and over and over many times, when the judge would simply say, well, this is a discovery issue, this should have been resolved many months before this, and I'm not going to deal with this now. So if you have the other side lying, or if you have the other side not disclosing to you things, the first step you have to do is you send 21K letter, pretty much saying that I believe that you're not honest with me, and this is what I'm looking for. If you still cannot resolve this, then you have to have a phone call. And that's what sometimes lawyers forget about. You have to pick up the phone and talk to the lawyer, or the other side, about this discovery issues. That's what the courts encourage us to do. If that still does not resolve your discovery issues, you file what's called motion to compel, and you ask for sanctions. If you win, if the court indeed finds that the other side playing this discovery games and didn't disclose you, didn't give you enough information, trying to hide information, you can seek sanctions. Sanctions can be different. You can ask for the attorney's fees that your client has to spend for this motion to compel, or you can ask the court to bar, restrict the other side from a testimony during the trial about certain aspects of the case. In the example that I gave you before, we ask for sanctions against the other side because they did it. They still, even we sent them a subpoena and we needed full disclosure from them, they still wouldn't give it to us. So as sanctions, we ask that the court will presume that this $200,000 were saved in a separate account, that it's marital property, and there can be no argument about it. So this way, you kind of lock your argument, and the other side cannot object to it during the trial. Or you can sort of cure the discovery issue and provide all of the information that the other side wants from you.
So I assume you have seen situations where financial discovery revealed issues not initially part of the dispute. How did that work out?
When the financial issue is not a part of the initial dispute,
The discovery reveals issues that weren't part of the initial dispute.
we submit financial affidavits at the very beginning of the case. The law says that it's done under oath, and everybody have to be honest about the income, about the assets, about the debt. And debt is, by the way, is also one of the biggest financial issues that could be dealt with. But the parties usually try to minimize their income and show that, hide assets. It's in a rare it's a rare circumstance when everybody is completely honest. But um, and you anticipate that something will be discovered later on, and these things come into play all the time. Let's say there is a marital business, and what's marital business is not necessarily an entity that is governed or run by the husband and wife. It can belong only to one of them, but if it was opened during the course of the marriage by one of the spouses, let's say it's a trucking business that the husband owns, well, it's marital, and the trucks and the trailers that operate in that business, the equipment, it belongs to the family. And what happens a lot in these cases, with truck driving industry, is that the trucks would be titled to somebody else's name, but owned by the husband. And that's where you have to prove the sort of nexus and connection between when the truck was purchased, who used the money to purchase the truck, and you try to follow the trail of the money. And that's exactly what happens in this case. When you come up with discovery, then you ask for a deposition. And that's also a tool that I really like in my practice. I really like in person depositions. I don't necessarily, I do depositions by Zoom, but when you are in person, and the other side, it sits, on the other side, and you and your client sits on this side, and you're face to face, and now you have a court reporter and you're under oath, and you show these documents that you discovered during the written discovery. You show page one was the title, you show page two was the receipt for the purchase of a truck, and you show page three where you see the transfer of from one bank account to another bank account or cashing out, and you're asking the other person under oath to explain. the transaction. And that's when really all the truth is coming out, because they have to explain it to you.
What mistakes during discovery can hurt a party's credibility with the court?
The judges are very smart, experienced people
Mhm.
in the area where I practice, in the meaning the field of the family law. The judges usually not elected from just out of law school. They are practitioners that had either worked for somebody or had their own practice, and they kind of know from the inside how this works. So when one of the common issues that I encounter, if you represent a self-employed person who has business, and this person, I just had a case when this person is making, and that's one person company. He was fixing dents on cars, and he's making about $300,000 in gross per year, and he is showing on his tax returns that he's barely making in net income $20,000. That is a huge misconception, but by a lot of people. They think that just because you've been making this money for 5 years, and you've been showing all of this income, and now a year before divorce, all of a sudden doing the same job, you making three times less, and then the next year you're making three times less again. Like I said, judges
Mm.
they know, they've been there, they saw that before. And just because you filed it with IRS, you probably committed fraud with IRS, and that's a different issue. But just because your tax returns that you prepared yourself, or your accountant prepared it for you, doesn't necessarily mean that you now all of a sudden making less money than you used to make. And then during deposition, when you ask this person, can you explain to me that having the same amount of customers, and having the same rates, and staying in the same business, and nothing else why do you have this much of income instead of what you made before? And that's when the person starts lying, trying to say that now equipment is more expensive, or I have to pay for gas more. Probably you are, especially nowadays, but not that much. And when the judge sees the person lying under oath, it goes towards credibility. And if the judge doesn't believe you, you're done.
It's as if the judges weren't born yesterday.
Exactly. And that for some reason, people think that whatever they're going to present through lawyers, they don't usually do it. So the lawyers have to present it to the judge, and the judge has to accept it. And they get upset why the judge is not accepting it. But that's why we have the litigation. That's why we have trials.
Well, that is it for today's episode of the Family Law Frontline. If you are involved in a contested divorce and want to understand how discovery may shape your case, visit lawyer-il.com to connect with Fedor Kozlov and his team. Thanks for listening, and remember to like, subscribe to the show, and share this episode with someone who might need it. Thank you, Fedor.
Thank you, LeAnn.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.